Welcome and thank you for standing by. At this time, all participants are on listen-only mode for today's conference until the question and answer sessions. At that time, you may press star 1 to ask a question over the phone line. This conference is being recorded. If you object, you may disconnect at this time. I'll now turn the conference over to Yvette Riddick. Thank you. Please begin.
Hello, this is Yvette Riddick, and I'm the Director of the Division of Policy and Training at OCSC. And on behalf of Commissioner Scott Lucan, I wanted to say hello for him. He is not available, so I'm here in his place. And I'm very, very pleased to be able to welcome you to the third webinar in a 6-part training series on interstate case processing. This one is on interstate scenarios. We have about over 800 registrants again for the webinar today. It's been really an incredible ride. We've had so many participants, 800 plus just about every time, and we are so happy for that since we have developed these trainings for you, our state partners, and we're very pleased that so many of you are finding these trainings useful. Thank you again for those of you who have gathered together in groups to participate in the webinar. This really helps us save resources, and we really appreciate the effort. So many of you during the past webinars and in the evaluations have commented on wanting to have more time for questions. And so I want to talk about this with you briefly. Because we have so much to cover in the webinars, and because it's such a large audience, not to mention that many of the questions can be very complex, we are not able to address every question during the webinar itself. Therefore, we invite you to send all of your unanswered questions to OCSC about the webinar using the email address at the end of the presentation. Just want you to know that we are working on a question and answer document responding to many of the questions that came in during the Interstate 101 call and a couple of trailing questions afterwards. It's going to be a really big document. We've already been really working hard on it, and it's really been a lot of work, but we realize that it's very, very important that we be able to answer your questions. This document will be distributed to the registrants for each of the calls. So after the Interstate Training Series is completed in February, we will consolidate all of the questions and answers from each of the webinars into one document, and at that time we'll issue an official OCSC policy document that addresses the questions. Meanwhile, so that we can respond to you in a timely manner, we are providing you answers to your questions in a more informal way than we normally do. So please keep that in mind, but we will find them helpful. Before I turn you over to our presenters for today, Jeanette Savoy and Diane Potts, I also want to take the opportunity to thank you for the hard work that you do every day in serving our families in the child support system. Please let us know how OCSC can further support you, and we hope that this Interstate series, Intergovernmental series, is very helpful for you. And now I will turn you over to Jeanette and Diane. Jeanette?
Thank you, Yvette. I also want to thank everyone who participated in the Interstate 101 and 201 trainings, with a special thanks to those who responded to the post-webinar evaluation. As Yvette mentioned, for today's trainings, we'll do our best to answer your questions. But if you have a question that is not answered today, you'll be able to submit it directly to OCSC after the webinar using the email address listed on the final slide, and OCSC will respond. This will also help us if we need to get clarification on the question. Okay, without further ado, welcome to Interstate Scenarios training. Today, we're going to cover several scenarios related to topics covered in the Interstate 101 and 201 trainings. We'll be referencing both federal regulations and UWIFSA, and remember that UWIFSA is the acronym for the Uniform Interstate Family Support Act, which all states are required to have in their state statutes. UWIFSA provides uniform rules and a framework for child support cases when the parties live in different states. We are using real state names in the scenarios just to help with our discussion, but they're randomly chosen and not a comment on any state. This is a general training, and your state may have additional procedures for interstate cases. We will give you an opportunity to ask questions several times during the session, and if you would like to submit a written question, please do so through the Q&A on the right side of your screen, and it defaults to all panelists. That's where it should be sent. Because we're doing scenarios, you will be asked to provide your response after each scenario is presented. The possible responses will appear on the right side of your screen. If you're viewing the slides in the full screen mode, you may want to exit the full screen so that you can view the poll and the scenario at the same time. Select your response by clicking on the button next to the answer you believe is the most appropriate, and then clicking on the Submit button. If you're listening as a group, provide the most popular answer in your group. After the responses are received, we'll discuss each scenario. We'll be able to see how many people selected each response, but your specific responses are anonymous. These are the 6 training modules in this series. We've done both Interstate 101 and Interstate 201 with basic materials on the laws and processes for interstate cases. Today's session will focus on interstate case scenarios, and future trainings include interstate payment processing and case closure, and interstate tools and resources. All of these trainings are intended to complement rather than repeat OCSE's trainings on the revised intergovernmental forms and international case processing. Next slide, please. So let's begin with a scenario related to receiving an application for 4D services. In this scenario, Clarice walks into your office in Illinois and says that she needs child support for her 2 children. The family lived in Hawaii when they separated, but she isn't sure if there was ever a child support order. Howard, her ex-husband, lives in Montana. So what is your next step? And the possible answers are A, establish an order since Clarice can't provide a copy of an order. B, require Clarice to find out if there is an order before accepting her application fee. Or C, use Quick or make an FCR query to determine if there is an order or a case in another state. The poll is now open. You might notice a timer above the question that has a 5-minute limit for responses. This is a program default that we can't change, but we'll give you a maximum of 2 minutes for each question. And when we see that most of you have responded, we'll close the poll. And as a reminder, click on the button next to A, B, or C, depending on which answer you feel is most appropriate, and then remember to click the Submit button. I believe that the poll is closed. Liza, can you post the results? Great. It looks like most of you got this answer correctly. So let's review that response. Whenever a child support agency receives an application for services, an important first step is to analyze and research the case. And before taking action on the case, it's critical to know if there was ever a child support order issued or if another state has an open case for these parties. And to do that, of course, you're going to use answer C, QUIC or FCR. If you learn that an order or a 4D case exists, you'll most likely have to contact the other state's worker or central registry for specific information and a copy of any order that was issued. Doing these searches before determining the appropriate action on a case can prevent potential problems. You do not want to establish an order when one already exists, of course, or enforce an order when another state is already enforcing the same order. There are several federal tools, such as QUIC or the FCR query as mentioned here, that will help with this research. Before we move on to the next scenario, let's review these federal interstate communication tools in case you're not familiar with them. QUIC is the acronym for a federal tool available through the OCSE Child Support Portal called Query Interstate Cases for Kids. QUIC provides a real-time look into cases, both 4D and non-4D, in other states. Another great tool is the Federal Case Registry, or FCR. An FCR query is also available on the portal. When a support order is established or a 4D case is opened, the state must send information about these activities to the Federal Case Registry. The FCR query allows you to find information on cases and orders in other states. The Electronic Document Exchange, or EDE, allows you to send forms and documents to other states and receive them through a secure system. You wouldn't use EDE to look up interstate information, but you can use it to send an intergovernmental transmittal requesting information or documents from another participating state. The Child Support Enforcement Network, or CISNET, is another communication tool that transmits information through an automated batching system. And lastly, the Intergovernmental Reference Guide, or IRG, on the OCSE website and the portal has a wealth of information on states' laws and procedures, as well as contact information. It also has information on tribes with 4D programs and 4D countries that have joined the Hague Child Support Convention or have reciprocating agreements with the United States. OCSE's Interstate Tools and Resources, Session 6 of this Interstate Training Series, is devoted to providing a more comprehensive look at these important interstate tools. Now I'll turn you back over to Diane.
Thanks, Jeanette. So let's move on to scenarios involving the establishment of parentage and support in interstate cases. For our scenario 2, Martha applies for 4D services in Maryland, where she lives with her child, Joseph. There's no order in the case. The father, Roger, is in Georgia. The Maryland 4D agency files a child support case in Maryland court. Which of the following is not a basis for long-arm jurisdiction when establishing an order? A, the child was conceived in Maryland. B, Roger sent money to Martha for the child while he was living in Georgia. C, Roger was in Maryland visiting his parents and was personally served with a summons while he was in Maryland. Roger filed a response with the court in Maryland stating that he does not think he is the child's father. We're going to go ahead and open the poll. As a reminder, we'll give you a maximum of 2 minutes for this question, and when we see that most of you have responded, we'll close the poll. Please click the button next to the answer you feel is the most appropriate, and then please remember to click the Submit button.
Diane, this is Liza. We're about 50% response rate, so I'm going to give it about 10 more seconds, and then I'll close up.
Okay, thank you, Liza. Okay, the poll is now closed. Let's see what the responses are.
WebEx is giving us about 5 more seconds to clear people's responses, and then I will post.
Thanks, Liza. Okay, so the majority of you picked B, and you are correct. There's only one of the 4 responses that cannot be used as a basis for long-arm jurisdiction under UIFSA, and that's number 2, answer B. The non-custodial parent sent money to the custodial parent while he was living in Georgia. This does not prove any minimum contact of the non-custodial parent with the forum state of Maryland, which is required to establish personal jurisdiction. However, if Roger sent money to the custodial parent to help support the child while he lived in Maryland, this would be a basis for long-arm jurisdiction. The other 3 answers are facts that provide a basis for long-arm jurisdiction under UIFSA. Remember that if Roger enters a general appearance or files a responsive document, unless the response is to claim that the court does not have personal jurisdiction, he submits to the personal jurisdiction of the state. So if there's no basis for personal jurisdiction, what's the next step for the Maryland 4D agency? If you're thinking that the agency should prepare and refer an interstate case to Georgia, requesting establishment and enforcement of an order, you're correct. So let's review the forms that are needed for that action. On the side, there's other federal forms Maryland will need to include to refer an interstate case for establishment. The Child Support Enforcement Transmittal Number 1, initial request, and the Child Support Agency Confidential Information Form must both be included with any referral asking another state child support agency to open an interstate case. The Child Support Agency Confidential Information Form is intended for agency use only. Because of the personally identifiable information it contains, it should not be provided to the parties or filed with the tribunal. In many states, the Child Support Enforcement Transmittal Number 1 is not filed with the tribunal. However, in some states, the Transmittal Number 1 may be filed with the tribunal and disclosed to the parties in the case unless it's accompanied by a nondisclosure finding or affidavit. The Uniform Support Petition is a legal pleading that is filed with the tribunal. The Personal Information Form for UIFSA Section 311 is also filed with the tribunal along with the petition. These forms, along with the general testimony, may be provided to the other party in the case unless there has been a nondisclosure finding or an affidavit requesting nondisclosure of information. If parentage needs to be determined, the agency must also include a declaration in support of establishing parentage for each child. There also are other documents the responding agency might require, such as a copy of the child's birth certificate, the custodial parent's pay stubs and tax returns, and documentation of ongoing expenses, including child care and any extraordinary medical expenses. The resource slide at the end of this presentation contains a link to the Intergovernmental Forms Matrix, designed to assist you in determining which forms to include with an interstate case. Now I'll turn it back over to Jeanette.
In this third scenario, we have an open 4D case in Pennsylvania, and the order was issued also in Pennsylvania. The child, Jesse, is 18, still living with the custodial parent, Florence, and no longer in high school, so has reached the age of majority under Pennsylvania law, but arrears are still due. The non-custodial parent, William, lives in New York. Florence knows that the age of majority in New York is 21. She wants Pennsylvania to ask New York to issue a new order so that William will still owe current support until Jesse's 21. After all, she's still supporting him. So Pennsylvania should agree to do this. The answers are A for true or B for false. So you can see that the poll is now open. Click next to your response and remember to click the submit button.
I'm closing the poll, and we have about 18 seconds or so for people to submit their responses.
Thank you, Liza. And it looks like the results are in, and most of you got this answer correct. The answer in this scenario is false. UIFSA prohibits a state from changing an aspect of another state's order that is not modifiable in the issuing state, which typically includes the duration of support. That means that although a state may have jurisdiction to modify an order, the duration of support remains set by the law of the state that issued the initial controlling order. In addition, UIFSA prohibits a state from establishing any further child support obligation once the child has reached the age of majority under the original order.
So let's move on to scenario number 4. Dorothy and her 2-year-old child live in the state of Louisiana. Scott lives in Vermont. Dorothy and Scott are not married, but both signed an acknowledgement of paternity in Louisiana. Louisiana refers a case to Vermont requesting support establishment. Scott claims he's not the father and should not have to pay support. Vermont can allow Scott to relitigate paternity. Click answer A if you believe that statement to be true. Click answer B if you believe that statement to be false. And then please remember to click the submit button.
Diane, we're about 75% response rate, so I'm going to close in a couple of seconds, and then there'll be 20 seconds to clear people's answers.
Okay, thank you, Liza. And the results are in. And many of you got the answer correct, which is false. The statement that Vermont can allow Scott to relitigate paternity is not true. Vermont does not have the authority to relitigate paternity. UIFSA states that a party whose parentage of a child has been previously determined by or pursuant to law may not plead non-parentage as a defense to a proceeding under this act. If Scott wants to raise the issue of parentage, that must be done in Louisiana, where his parentage was established by signing the voluntary acknowledgement. How the case is handled in Vermont at that point depends largely on state procedures and statutes. Many tribunals will issue a support order based on the acknowledgement. UIFSA also allows the tribunal to issue a temporary support order if the individual ordered to pay is an acknowledged father. A temporary order would allow time for resolution in the state with the acknowledgement. Sub-tribunals might issue a time-limited stay of the proceeding, again, to allow time to resolve the issue in the state with the acknowledgement. The most important point here is that Vermont cannot relitigate parentage that was established in another state.
In scenario number 5, Grandma Joan has custody of Sally and Rick's twins and applies for services in Colorado. There's an Alabama order for Rick to pay child support to Sally, and Rick and Sally are also both in Colorado. Colorado should establish a new order, as there's no order for Rick to pay Grandma Joan. Please enter A for true or B for false. The poll is open. Remember to submit your answer and then be sure to click the Submit button.
All right, Jeanette, in a couple of seconds, I'll close the poll, and then we'll wait for the system to clear.
Okay, thanks, Liza. And as you can see, the poll is closed and the responses are pretty split on this one. The majority of you answered correctly, which is false, but a significant number also answered true. So while some people might believe that Colorado should establish a new order because there's a new custodial party, this is incorrect because UIFSA prohibits the establishment of a new order when there's an existing order involving the same obligor and child. Obviously, the goal is for Grandma Joan to receive support payments. However, from the facts, we don't know if there's been a legal change of custody or if the change of physical custody is long-term. States will handle this fact pattern in different ways. Some states may be able to administratively change the payee to Grandma. Other states may believe that the proper way to proceed is through modification. Because neither the custodial parent, non-custodial parent, or children reside in the order-issuing state, which is Alabama, no state has continuing exclusive jurisdiction, or CEJ, to modify the order. However, because all the parties live in Colorado, the order can be registered there and modified if necessary. Still, other states may ask Alabama for guidance. The important thing to remember from this scenario is that Rick cannot be obligated twice for current support for the same child.
Now, before we move on to a few scenarios covering interstate enforcement, we wanted to see if there's any questions on interstate establishment. Remember that you can submit questions using the Q&A box on the WebEx screen, or you can do that over the phone. Operator, if you could please instruct folks on how to do that and open the phone lines, we have time to take some questions.
Absolutely. At this time, if you'd like to ask your question over the phone line, first please ensure your phone is unmuted, then press *1 and record your name when prompted to enter the question queue. Your name is required so I may introduce your question. Once again, that is *1 to enter the question queue on the phone. That does take a few moments to queue up. Please stand by.
Thanks. While we're waiting, Liza, do we have any questions in the Q&A on the WebEx?
Hi, Diane. This is Ann. Yes, we have a question. In the last scenario, would it be appropriate to establish a new order for the mom to pay, or should a to-obligor modification be done?
Oh, that's an excellent question, because the mom is a non-custodial parent at this point in our scenario. And so I think it would be appropriate for a mom to pay. Jeanette, what do you think?
Again, I think different states will handle this differently. Some establish a new and separate order, while some make both obligors obligated in the same order. So I think however the state handles that is appropriate, but definitely the mom should also be required to pay support.
Yes, thanks. Yeah, I agree completely that the child in the scenario deserves support from both parents. So I do see that we have another question in the WebEx. Let's see. Okay, so we have a question. Could you please explain why the answer was B in scenario 2? So let's go back to that scenario and let's see. So in that case, this has to do with the long-arm jurisdiction. UFSL lists a number of things that will subject an alleged father to jurisdiction when he's not a resident of that state. But the one that, of the four that UFSL does not provide for is just the simple fact that Roger sent money to Martha, but he was still living in Georgia. If he was living in Maryland when he did that and he was supporting the child, that would be a reason to establish long-arm jurisdiction. So thank you for that. So, operator, do we have any questions on the phone lines?
I'm showing no questions from the phone lines.
Okay, Jeanette, is there any question on the WebEx that you would like to speak to?
There are several about the last scenario, and I think it's because states handle it so differently. But there's one question that says, in the last scenario, what if Alabama suspends their case so there's no active order? Can Colorado now establish an order with grandma and the parents? And I think that is how some states handle it. They suspend or abate, or whatever word you want to use, terminate current support for the active order, and then a new order can be established. That is how some states handle it. I think the important thing is that you have to work together on it and make sure that the obligor is not actively obligated twice. There's also a question, are there any plans for a universal federal database to obtain voluntary acknowledgments of paternity? And getting these documents is increasingly complicated. As far as I know, there is no plan for that. If anybody from the federal office wants to chip in, you can, but I don't know of any plan to make that happen at this point.
So this is Yvette. We're not, we don't have any plans at this time. We're always adding new stuff. That is, if there's enough desire and enough interest and there's enough technology out there, we are always taking suggestions. That's how Quick and ED and SESNet all came about over time. So we're always open to new ideas. But at this time, we do not have any plans.
Thanks, Yvette. And I'll just go ahead and take one final question off of WebEx, and that's, are birth certificates required documentation for establishment of support order? And as Jeanette spoke to, states have different requirements on that. There certainly are a good number of states that require birth certificates for the establishment of a support order. What do you think, Jeanette?
Yeah, I think that that's true. Many states and many courts do want to see the birth certificate, especially if parentage is an issue. Courts often will want to ensure that there is no other father listed on that birth certificate before they go ahead with establishment of parentage. So it is often required. But typically a copy is fine.
Mm-hmm. Okay, great. Thanks so much, Jeanette. So let's go ahead and we'll have two more opportunities for questions. There are some great questions today. Thank you so much for submitting them. So let's talk now about scenarios involving enforcement in interstate cases. And we'll go to scenario 6, in which we've got the custodial parent, Sarah, living with her child in Nevada, and she's applied there for 4D services. The custodial parent tells the caseworker that Delaware issued an order in the case, but she lost it moving to Nevada. The non-custodial parent, Robert, lives in the state of Ohio, and in its case analysis, Nevada sends a transmittal number 3 to Delaware requesting copies of the order and payment records. The question for you is Delaware required to cooperate with this request? Please select A, yes, or B, no. The poll is now open. Please remember to click your submit button after you select your response.
I'm closing the poll, so you have 20 seconds for those of you who haven't quite hit the submit button. Thanks, Diane.
Thanks, Liza. Okay, the poll has closed and the results are in. Most of you selected the correct answer, which is yes. Delaware is required to cooperate with this request. The request is going to be received on the Child Support Enforcement Transmittal number 3, Request for Assistance Discovery. As we talked about in Interstate 201, federal regulations require states to cooperate with each other and provide assistance in certain types of limited services requests. These are quick locate, service of process, assistance with discovery and genetic testing, teleconferenced hearings, administrative reviews, high-volume automated administrative enforcement, and copies of court orders and payment records. In the spirit of cooperation and to ensure success in interstate cases, states are encouraged to honor requests for other types of limited services.
Moving on now to scenario 7, Ruth lives in Alaska with her 3 children and applies for 4D services there. The father, Howard, lives in California, and there is an Alaska divorce that includes a child support order. If Alaska refers a 4D case to California to register and enforce the order, can California reject the case because Alaska could have enforced the order directly? And you're going to enter A for yes and B for no. And you see the poll is open. Remember to click submit once you've responded.
Jeanette, I'm closing up the poll. Please wait 20 seconds for the submissions to clear. Thanks.
Thanks, Liza. And here we have the results, and the majority of you answered correctly. The answer to this is no. California cannot reject the case, even if they believe that Alaska could have enforced the order through direct income withholding. Remember that this is a decision that the initiating state makes based on the facts of the case.
Okay, so using the previous scenario, let's say Alaska refers a 40 case to California to register and enforce the order. The statement that you have to decide whether it's true or false is California must register the order with the court. Please select A, true, or B, false, and then remember to click the Submit button. Okay, the poll has closed and the results are in. Most of you believe, or the majority believed the answer to be true. That's not correct. Those that selected false, you are right. California, as the responding state, will make the decision whether to register the order or enforce it administratively. This is allowed under UIFSA, which in fact states that the Support Enforcement Agency shall consider and, if appropriate, use any administrative procedure authorized by state law. However, if the non-custodial parent contests administrative enforcement, or if the agency decides a judicial enforcement proceeding is more appropriate, the agency must register the order with the appropriate tribunal. So when referring a 40 case asking a state to enforce another state's order, you must include these required federal forms: the Child Support Enforcement Transmittal Number 1, Initial Request, the Child Support Agency Confidential Information Form, and the Letter of Transmittal requesting registration. In this situation, you must also include 2 copies, one being certified, of the order, including any modification of the order, and any payment histories or arrears affidavits.
If you would please take the, oh, you did take the poll down, excuse me. In scenario 9, from the previous scenario, again, California is enforcing the Alaska order at the request of Alaska. Which one of these enforcement remedies is not appropriate for an appropriate option for California to take? A is income withholding, B, driver's license suspension, C, certification for federal tax refund offset, or D, credit bureau reporting of the unpaid amount. Again, the poll is open. Click next to the answer that you feel is most appropriate, and then click Submit.
I'm going to close the poll in 5 more seconds, and then please wait for the submissions to clear. Thanks, Jeanette.
Yep, thank you. Okay, you can see the results. Looks like the majority answered this one correctly. Certification for federal tax refund offset, option C. In an interstate case, the responding agency is responsible for most of the enforcement actions. Federal regulations require the responding agency to process and enforce orders referred by an initiating agency using remedies it would apply in its own intrastate cases. The one exception is that the initiating state is responsible for submitting the case for federal tax refund offset. I do see that several of you answered credit bureau reporting, and that was changed in 2010 with the new requirements, and that's now a responding agency responsibility. Of course, communication between caseworkers is critical to ensure that these remedies are used appropriately and that both states understand the actions of the other states to avoid duplicative enforcement actions.
Okay, so let's move on to scenario number 10. In this case, South Dakota receives a referral from Minnesota to register and enforce a Minnesota order. South Dakota sends a notice of registration to the non-custodial parents. The question is, which of the following is not a defense to registration of the order? A, the issuing tribunal lacked personal jurisdiction over the non-custodial parents. B, the order was obtained by fraud. C, the monthly obligation of support order is too high. Or D, full or partial payment has been made. Again, click on the button next to the answer you feel is the most appropriate, and remember to click the Submit button. The poll is now open. Okay, the poll has closed and your responses have been posted. And in this, for this scenario, the majority of you answered correctly. It's C. UIFSA details the valid defenses when contesting the registration of an order. The only one in this list that cannot be used as a defense is that the monthly obligation of the support order is too high. If the issuing state had jurisdiction to enter the order, no substantive part of the order, such as the monthly obligation, can be contested during registration. The non-custodial parent can, of course, request a modification of the order, especially if his or her circumstances have changed. However, the modification request must be made in a state with jurisdiction to modify the order.
Now in scenario 11, Idaho is enforcing its own order issued in 2012 for custodial parent Marty and non-custodial parent Rusty. The Idaho Central Registry receives a case from Arizona with a request to enforce a 2015 Arizona order for the same parties. Rusty lives in Idaho and Marty lives in Arizona. The Idaho Central Registry should, A, return the interstate packet and tell Arizona that their order is void, B, inform Arizona about the Idaho order and request their assistance in having their court vacate the Arizona order, or C, open the interstate case but enforce the Idaho order as the Arizona order is void. And you can see the poll is now open. Click on A, B, or C, and then click the Submit button.
This is Liza. I'm going to wait a few more seconds because this is a hard one, and then I'll shut it down, and then we'll have 20 seconds for the responses to clear.
Thank you, Liza. And now you can see the results. And it looks like the majority of you, about 60%, answered this one correctly. The correct answer is B. And that's because both the Full Faith and Credit for Child Support Orders Act, which is called FCSOA, and UIFSA prohibit the establishment of a new order if a valid order already exists. This sometimes does occur in interstate cases, though, as the second order might be established by an agency or a court that has no knowledge of the first order. The key to preventing this situation is a thorough investigation at the time a case is opened to identify the existence of an order or a 4D case in another state. The correct answer here is that the Idaho Central Registry should contact Arizona to discuss the issue and request their assistance in having their court vacate the Arizona order. A tribunal must make the determination on the validity of a subsequent order, not the caseworker or the Central Registry. There might also be other facts that they aren't aware of. For example, maybe both the parties were in Arizona and the Arizona order is actually a modification of the Idaho order. As with all areas of interstate case processing, communication is the key to success, and the goal is to provide support for the children.
Okay, so before we move on to modification, I want to see if there's any questions out there on interstate enforcement. Remember, you can submit questions using the Q&A box on the right-hand side of your screen or over the phone. Operator, if you could please remind folks on how to do that over the phone and open the phone lines.
Absolutely. Once again, that's *1 to ask your question over the phone line. Stand by, please.
Okay, thanks. While we're waiting for that, we do have a number of questions on the WebEx. One question relates to Scenario 6, which was the limited services request. And the question from Alicia is Delaware required to cooperate with providing a copy of the order if the case is not an open 40 case anymore in Delaware? And the answer is yes, it is. It's not Delaware would have to comply with that request regardless of whether it had an open 40 case for the parties or not. And a related question there is from Barry Brooks in Texas. And what can Nevada do if Delaware refuses the limited services request? So my recommendation would be to point out to Delaware that federal regulations at 45 CFR 303.7 provide that a state 40 agency must cooperate with requests for the following limited services, which include copies of court orders and payment records. Jeanette, do you have any additional response for those two questions?
Yeah, I think this is, I would absolutely agree, Diane, and I think also this is something that is still sort of being worked on in terms of how states cooperate and what they consider cooperation. So I think working with that state and figuring out how to do it is probably the best thing going forward.
Okay, and I'll take one more question off of WebEx, and this is from Catherine. In scenarios 7 and 8, what's the difference between administrative registration and judicial? And I think the question goes to whether or not you have to register in order for enforcement, in order to enforce it in your state. And I would point you to UFS Section 507, which is the provision that talks about administrative enforcement of orders. And subsection D of that provision requires that upon receipt of documents, the support enforcement agency, without initially seeking to register the order, shall consider and, if appropriate, use any administrative procedure authorized by the law of the state to enforce a support order. And so I think the most common example here would be that if you received a request for registration and enforcement and the obligor wasn't, you could find employment for the obligor, you can go ahead and send that income withholding order without doing anything in the tribunal. That's an availability that you have under UFSA and under federal regulations. Jeanette, do you have anything additional on that one?
No, I think that was great. I would just add that this may come from a person whose state doesn't have a lot of administrative enforcement capabilities. Many states can do license suspensions of all sort, et cetera, administratively, and some have to be judicial. So it really depends a lot on what your state does.
Mm-hmm. Thanks, Jeanette. So, operator, do we have any questions on the phone lines?
Yes, we do have one question submitted on the phone line. It comes from Ashley. Your line is open.
Hi, this is Ashley from Louisiana. In regard to scenario 11, we were wondering about the determination of a controlling order. Does that possibility exist under UFSA, or does the determination of controlling order go away with UFSA?
So I'll answer first, and Jeanette, jump in here. Certainly the determination of a controlling order is something that is provided for in UFSA, but it was largely intended to take care of the multiple orders that existed under ERISA and RERISA. And so in this scenario, we were portraying it more as an improper order being entered by the state of Arizona without, because it didn't have modification jurisdiction. Now, we pointed out in our answer that Arizona may have had modification jurisdiction, and that's one of the things you need to find out in deciding what's the most appropriate action in this case.
Yes, ma'am. We did understand the scenario. We just wondered if a determination of controlling order would be a proper remedy, or if vacating or asking them to vacate their order would be the proper way to go in all situations like this.
So, Jeanette, do you have a thought on this? That's a really good question.
One thing I would say is that courts really, if their order is going to be vacated, they would like to do it themselves. Certainly the court in the responding agency can do it, but you do need to sort of be aware that, as Diane said, the determination of controlling order is done when there are two valid orders. And in this case, you have a valid order and then a subsequent order that some states would consider void and some voidable. But, you want to be careful with that determination of controlling order. I think the best possibility is to get the original court to dismiss that order.
All right, thank you.
Thank you. Operator, are there any additional questions on the phone lines?
I've got no further questions from the phone lines.
Okay, and just one last follow-up. This comes from Barry Brooks in Texas, and that it was we presupposed that the Arizona order was void. We do recognize that there are instances in which Arizona may have had modification jurisdiction, and that subsequent order was a valid order, and that's part of the investigation that needs to go into the case. So thanks everyone for those really great questions. So this leads us into scenarios related to interstate modification. So for scenario number 12, our custodial parent, Mary, has a Tennessee support order. Mary still resides in Tennessee with the children. She applies for 40 services there and requests a modification. The non-custodial parent, Alex, resides in Oklahoma. So Tennessee should, A, proceed with modification of its order since Mary resides in Tennessee, B, refer a 40 case for modification to Oklahoma since Alex is there and Oklahoma is the non-requesting party state, or C, tell Mary she must apply in Oklahoma as Tennessee cannot modify the order. The poll is now open. Please remember to click the button next to the answer you feel is the most appropriate, and don't forget to click the submit button. Thanks. Okay, the poll has closed, and we're awaiting the results. Okay, the results are in. 55% of you that had answered picked the correct answer, which is A. It's the correct answer that Tennessee should process the request for modification because Mary lives in Tennessee and she lived there at the time of the request. So let's review the rules of CEJ for a moment. When a modification is requested, you must determine which state has CEJ to modify. The first question to ask yourself is, do any of the parties or the children live in the order issuing state? If that answer is yes, as it is in this scenario, that state has CEJ to modify the order, absent a consent filed with the order issuing tribunal for another state to modify the order and assume CEJ. If the parents and child live in states other than the order issuing state, that state no longer has CEJ, but with one exception. The parties can consent to the order issuing state retaining jurisdiction to modify the order.
Let's look now at another scenario about modification. In this scenario, the custodial parent, Randolph, and child, Rudolph, live in Texas. The child support order was issued by Colorado, and no 4D agency is enforcing. The non-custodial parent, Suzanne, lives in Nebraska and applies for services in Nebraska to request a modification. Nebraska should, A, register and modify the Colorado order since the non-custodial parent requested it, B, establish a new order since none of the parties now live in Colorado. C, tell the parties that they have to get the modification done privately since Colorado has no 4D case. Or D, refer an interstate case for registration and modification to Texas since that's where the other party lives. So the poll is now open. Click on the answer you think is most appropriate, and then click on the Submit button.
This is Liza. This is a hard one. I'm going to give another 5 or 10 seconds before closing.
Thank you, Liza. And it looks like she's closed the poll. While we're waiting that few seconds, I did see a Q&A from Sonia with essentially this same scenario, so hopefully this will answer your question, Sonia. Now we'll wait for the results. And there we have, and the correct answer is D, and the majority of you certainly did get that one correct. If no one lives in the order issuing state and there's no consent for the order issuing state to retain CEJ, the modification must be requested in the non-requesting party state, and we call this the play-away rule. Nebraska must refer an interstate case to Texas to register and modify the Colorado order. When there's an existing support order, UIFSA prohibits entry of a new order, as we've talked about. It certainly is not appropriate to tell the parties that they have to obtain the modification on their own, of course. Now let's look at the federal forms that would be required for Nebraska to refer a 4D case to Texas for registration and modification of another state's order. And they include the Child Support Enforcement Transmittal Number 1, Initial Request, the Child Support Agency Confidential Information Form, the Uniform Support Petition and General Testimony, and the Personal Information Form for UIFSA Section 311, along with a letter of transmittal requesting registration. Note the need for that additional form, the letter of transmittal requesting registration, since the order must be registered in order to be modified. UIFSA also requires 2 copies, one certified, of the order to be registered and any modifications of that order, as well as a sworn statement by the person requesting registration or a certified statement by the custodian of the records showing the amount of any arrearage. Again, there are other documents that the responding agency might require, such as the non-custodial parent's pay stubs and tax returns and proof of any changed circumstances that may be the basis for this modification request.
So let's move on to scenario number 14. We're going to use the previous scenario, and we're going to assume that Texas modifies the Colorado order. So the statement, this changes the duration of support from 19 under Colorado law to 18 under Texas law. Please select A if you believe that statement to be true. Please select B if you believe that statement to be false. The poll is now open, and please remember to click your Submit button after you make your selection. Okay, the poll is closed and the results are in. 65% of you that answered selected the correct answer, which is B, false. Remember that the duration of support is set by the law of the state that issued the original controlling order. No matter how many states modify that order, the duration of support will continue to follow Colorado law. Information about each state's duration of support, or age of majority, can be found on the IRG.
Scenario 15 is our final scenario. The custodial parent, Sheldon, and his 2 children live in Oregon. The non-custodial parent, Cindy, is in Washington. At Oregon's request, Washington is enforcing the Oregon order that was issued just 1 year ago. Sheldon, though, requests a modification from the Oregon 4D agency because Cindy has received a promotion at work. So the possible answers that Oregon should do are A, refer an interstate case for modification to Washington, as that's the non-requesting party state. B, review the case for modification in Oregon. Or C, deny the request as it hasn't been 3 years since the order was issued. And the poll is open. Please select your response and click Submit. And it looks like the poll has been closed, so we'll wait for those responses to come in. And there we have the responses, and it looks like the majority of you answered correctly. The answer is B, review the case for modification in Oregon. As we talked about in a previous scenario, since Sheldon and the children still live in the order-issuing state, which is Oregon, then Oregon is the state with CEJ to modify the order. The other important point here is that a party's request for a modification is sometimes incorrectly denied by the 4D agency if that order was issued less than 3 years ago. Federal regulations provide that if there's a change in circumstances, a modification may be warranted depending on the threshold set by the state with jurisdiction to modify the order. For example, some states require at least a 10% change in the monthly support obligation in order to modify the order. Others may have a higher or lower threshold. A common error in interstate cases is thinking that a modification request must always be sent to the non-requesting party state, and a number of you did answer that. Remember that the play-away rule only applies if there's no state with CEJ. It is important for Oregon, of course, to keep Washington informed about the modification and provide the new order if the previous order is modified.
Okay, on this slide, these are the links to resources that you may find helpful in processing interstate cases. The OCSC website has a wealth of information for you. Also, the Code of Federal Regulations, Title 45, Part 303.7, that was referred to in this training, is specifically about interstate cases. Every state has UFSA in its state statute, and it's best to access your own state's statute. But we have provided a link to a copy of UFSA. In this training, we've covered scenarios related to sections 201, 205, 315, 401, 507, 604, 607, 611, and 613. The final link is to the action transmittal on interstate payment processing. On this slide, these are the resources related to the federal intergovernmental forums. The forums and training on the forums, as well as the forums matrix, are on the OCSC website. So now we have just a little bit of time for a few more questions on any of the topics we've discussed during this training. Remember, you can submit questions using the Q&A box or over the phone. And operator, if you one last time can remind folks on how to open up their phone lines, I'd appreciate it. Thanks.
As a reminder, to ask a question, please press star followed by number 1 and record your name clearly.
And while we're waiting for that, I will take a question from Brian. Please comment on the federal rules about reviewing an order every 3 years or so. So it's 3 years is a requirement. State law can provide for a shorter time frame, but every state plan is required to review an order for adjustment every 3 years. But also important is to know that outside of that 3-year review, any time in which there is a request for a review and adjustment, because due to a substantial change in circumstances, the 40 agency is going to be required to do that and determine if there is a change in circumstances warranting a modification under the state guidelines. Jeanette, do you have anything to add to that one?
No, that sounds good.
Okay. Operator, is there anything on the phone lines? Anyone on the phone line?
We do have a couple of questions. Our first one comes from Martin. Your line is open.
I have a scenario that's similar to scenario 13. We received a transmittal 1 from the state of California with the NCP requesting a modification. We have an open case here, but it's a non-4D case. It's an Arizona order. So they want limited assistance. Would we be opening a case, then requesting the non-4D case to be closed, and then modify it? And what would they do? What would they do after that?
So thanks, Martin, for that question. That is pretty complicated. And so what I would like for you to do, at the very last slide, there's going to be an email. If you could submit that in case we need to follow up on particular circumstances in that complex scenario, and we'll get you an answer in short time.
And
okay.
Please be sure to indicate which states the custodial and non-custodial parents are in. That sort of really affects the answer.
Okay, because right now they're referring me to policy, and they're going to have me check that out. And but I'll go ahead and do that.
Okay, great. So before we take another question on the phone lines, we do have a question about, can you provide me with a copy of the PowerPoint for the July 12th Interstate 101 and September 13th Interstate 201 training? And the answer is yes. It's posted on the OCSC website. And Interstate 201 was posted today, I believe. So that should be a great resource for you, and it includes the presenter notes on that. As far as Carrie's question is every state required to be on QUIC? I am going to pass that to our OCSC folks in D.C. to answer.
Hey, Diane, this is Carrie Newcomb. There is not a requirement for states to be on QUIC. We currently have 46 states that are currently on QUIC, whether they're on for, all states have to program for the financial module. So we have all states that are currently providing information on financial, and then we have some states, or the majority of states, I should say, that are providing case activities and financial. So there is no requirement, but we do only have a handful of states that are not on QUIC right now.
Okay, thanks, Carrie.
Sure.
Jeanette, do you see any questions on the WebEx that you would like to answer?
Yeah, there's a one that I think is fairly easy to respond to. I think we have responded to other people. It's from Claudia. It says, in reference to the personal information form for UIFSA Section 311, I want to be clear that the form is not to be provided to the NCP, and that is incorrect. Anything that you file with the court is typically provided to the other party unless a nondisclosure of information has been requested. So if there's no nondisclosure of information requested, that form would be provided to the other party.
Thanks, Jeanette. Operator, do we have another call on the phone lines?
Yes, we do. Next question comes from Pat. Your line is open.
Pat, are you still on?
Yes. Can you hear me?
Yes, I can now. Thank you.
I have got a client who came to North Carolina. She and the NCP had a parenting agreement in Tennessee through the clerk of court. He now lives in Florida and she is here. Can we send the clerk of court order to Florida? There's no 4D involvement till now.
Mm-hmm. And where is the non-custodial parent? Where does he live?
Florida.
He lives in Florida, okay. And the custodial parent lives in North Carolina.
Right.
And it's a Tennessee support order?
Yes.
Okay. So, yes, you absolutely could send an Interstate 40 case from North Carolina. You'd be the initiating agency to Florida, and they would be the responding agency, and you'd ask them to register for enforcement the Tennessee support order. Jeanette, does that sound right to you?
Yep, that sounds perfect.
There's no 4D involvement till now. This is a clerk of court case.
Yeah, that's okay. I assume that the custodial parent, since you referred to her as a client, she has applied for services in North Carolina, right?
Correct.
Okay. So what will happen is when you send that transmittal number 1 over to Florida with all the required documentation and forms, they're going to open up an Interstate 40 case. They're going to be the responding agency. So although they don't have an open 40 case now, they will after they receive the transmittal over with all the forms to their central registry.
Thank you.
Diane, I do just see a comment that people couldn't hear the North Carolina question, so they're asking us to repeat it.
Okay. So the question came in. We've got the custodial parent in North Carolina. She has applied for services. It's a Tennessee support order, and the non-custodial parent lives in Florida. And the question was whether or not it would be what would be the services that they could provide in North Carolina, and the answer that Jeanette and I thought was probably most appropriate for this case would be that North Carolina could initiate an Interstate 40 case over to Florida seeking registration and enforcement of the Tennessee order.
And the one thing that I would add is in Tennessee, if the clerk of the court is actually enforcing, which sometimes they do, you want to make sure that you let them know that you now are enforcing the case, and they may ask you periodically to send payment records so that they can keep their non-40 account current in terms of payments that have come in.
Excellent point. That's absolutely right. So the Tennessee, because it is the state that issued the order, should be kept in the loop on any enforcement that's going on because under UIFSA, Tennessee, until another state assumes CEJ, Tennessee is going to be the one ultimately responsible for the correct arrears balance in that case. So keeping them informed is critical on that. So we are just about at time. I'm going to pass it over to Jeanette for our conclusion.
So this does conclude our Interstate Scenarios training. We have 3 more interstate training sessions for you in November, January, and February. Registration for these events will be available 2 to 3 weeks prior to the dates that we have listed on the slide, and we hope you'll join us for all these trainings as well. And as Diane mentioned, the recordings and the PowerPoints, including the trainer notes from all these sessions, are posted on the OCSE website for future use and to share with colleagues, and this one will be up in a few weeks. We do want to thank you very much for participating. Please use the email on this slide to send additional questions. We did get a lot of questions through Q&A that we were not able to get to all of them, so please feel free to send them in, and then we'll have your email address to be able to respond to you. Thanks again, everyone.
Thank you for your participation in today's conference. Please disconnect at this time.